Hi, my name is Anabela Campelo, and I will be discussing the constitutionality of the death penalty in America. The 1960s brought challenges to the fundamental legality of the death penalty. In the early 1960s, it was suggested that the death penalty was a cruel and unusual punishment and therefore unconstitutional under the Eighth Amendment. In the late 1960s, the Supreme Court began fine-tuning the way the death penalty was administered. To this effect, the court heard two cases in 1968 dealing with the discretion given to the prosecutor and the jury in capital cases. The first case was a kidnapping case where the court heard arguments regarding a provision of the kidnapping statute that required the death penalty be imposed only upon recommendation of a jury. But this was held by the court to be unconstitutional because the defendant could waive the right to a jury trial to ensure they wouldn't receive the death sentence. The second case, the Supreme Court held that a potential juror's mere reservation about the death penalty were insufficient grounds to prevent that person from serving on the jury in a death penalty case. They could only be disqualified if a prosecutor could show that the juror's attitude towards capital punishment would prevent them from making an impartial decision about punishment. In 1972, the death penalty was suspended. The Supreme Court ruled that the jury could not impose the death penalty alone because they were not informed about the law prior to hearing the cases. By 1976, states started reinstating the death penalty back. Most states implemented guidelines that allowed for the introduction of aggravating and mitigating factors in determining sentencing. These guidelines were approved in 1976 in a landmark decision by the Supreme Court. The court also held that the death penalty itself was constitutional under the Eighth Amendment. In addition to the sentencing guidelines, three other procedural reforms were approved by the court. The first was bifurcated trials, in which there are separate deliberations for the guilt and penalty phases of the trial. Only after the jury has determined that the defendant is guilty of a capital murder does it decide in a second trial whether the defendant should be sentenced to death or given a lesser sentence of prison time. Another reform was the practice of automatic appellate review of convictions and sentence. The final procedural reform was proportionately review, a practice that helps the state to identify and eliminate sentencing disparities. Through this process, the state appellate court can compare the sentence in the case being reviewed with other cases within the state to see if it is disproportionate. After World War II, the United States established limitations on capital punishment. In 1977, the United States Supreme Court held in Crocker v. Georgia that the death penalty is an unconstitutional punishment for the rape of an adult woman when the victim was not killed. Other limitations to the death penalty followed in the next decade, such as on June 20, 2002, the Supreme Court issued a landmark ruling ending the execution of those with mental retardation. In March 2005, the United States Supreme Court ruled that the death penalty for those who have committed their crimes at under 18 years of age was cruel and unusual punishment and hence barred by the Constitution. Race became the focus of the criminal justice debate. The court argued that there was racial discrimination in the application of the death penalty by presenting a statistical analysis showing a pattern of racial disparities in the death sentences based on the race of the victim. Support for the death penalty has fluctuated throughout the century. According to the Gallup surveys, in 1936, 61% of Americans favored the death penalty for persons convicted of murder. Support reached an all-time low of 42% in 1966. Throughout the 70s and 80s, the percentage of Americans in favor of the death penalty increased steadily, culminating in the 80% approval rating in 1994. Since 1994, support for the death penalty has declined. Today, 70% of Americans support the death penalty. However, research showed that public support for the death penalty drops when the poll's respondents are given the two choices a juror in the penalty phase of a typical capital trial would be given: death or life imprisonment without absolutely no possibility of parole. Given that choice, support for the death penalty drops to around 50%. It is no surprise that the topic of the death penalty has been going on for centuries and will continue for centuries to come. Whether you're in favor or opposed to the death penalty, there is still much to be debated surrounding this topic.